Good morning.
Good morning, Your Honor.
All right. Is it Studeman? Mr. Studeman?
Yes, sir. May it please
Is
the
that
court?
correct? All right,
Yes.
sir. Would you like to reserve any time for rebuttal?
Yes, 5 minutes, please, Your Honor.
You got it. You may proceed, sir.
May it please the court, Eric Studeman for the appellant, Chad McDaniel. The appellant's brief in this case cites numerous issues regarding child support calculation, which are subject to de novo review. In this case, the trial judge's pronouncement at the onset of trial regarding income stipulation is inconsistent with his pronouncement at the conclusion of trial and what was included in the final judgment. A little more specific on that, at the beginning of the trial, the judge had asked the parties if the appellant's income, as offered by the appellee in her exhibits, which were stipulated to, was correct. And before the trial began, the parties agreed, and the trial judge indicated that regarding income, he would only be hearing evidence regarding the appellee, not the appellant, but the appellee's income for 2020. Trial then proceeded. Very notably, the appellee did not call a single witness or offer any evidence at trial other than those exhibits that were already stipulated to at the beginning.
Mr. Studeman, the issue of the in-kind income that's listed on the exhibits, that was one of the agreed exhibits, right?
I'm sorry, I didn't understand your question, Your Honor.
The in-kind income that you're stating should not be included in the calculation of net income. The
Yes.
additional amounts, and I think they're called earning statements on the exhibits. Those exhibits, were they part of the stipulated agreed exhibits that went in?
There were numerous agreed exhibits. However, the trial judge was very specific as to the exhibits and the net incomes that the parties were stipulating to.
Well, yeah, but I guess my question is, you're arguing that the court had said that are these the stipulated incomes, but the income that has the in-kind, the additional payments that brings the gross income up and the net income up, those were actually part of those stipulated exhibits that were admitted at the beginning of the trial.
No, that's not correct, Your Honor.
No? Okay.
The parties stipulated to the admissibility of exhibits, but specifically they stipulated to the incomes in the
Affidavits. You're saying affidavits.
No, they were specifically in Exhibits 1 for 2018, Exhibit 3 for 2019, and Exhibit 5 for 2020. And those were proposed child support guideline worksheets, which were proposed by the appellee. And so when the parties were questioned about those specific exhibits and whether or not they agreed to the incomes, both the petitioner appellant and the respondent appellee agreed yes. And the judge proceeded to indicate that he would hear no other evidence other than regarding the appellee's income for the year 2020. And so when trial proceeded, there was absolutely no evidence offered regarding the income level for the appellant for the years 2018, 2019, or 2020. When the trial concluded, the trial judge then pronounced incomes for 2018, 2019, which were substantially higher, in one case almost 50% higher than those that were stipulated to. For example, the Exhibit 1, again, the proposed child support worksheet offered by the appellee, the 2018 income was $5,522. The trial judge pronounced $6,763. Then Exhibit 3, proposed child support guidelines worksheet offered by the appellee, the amount was $4,923 that the parties stipulated to. The trial judge pronounced $6,312. Then in Exhibit 5, the amount stipulated to was $4,878. The trial judge pronounced $6,854, a difference of more than $2,000 on a monthly basis. The party stipulated the incomes, and the judge said he wasn't going to hear any other evidence regarding those incomes, and therefore there was no trial regarding them. It was improper for him to then pronounce an entirely different amount after there was no opportunity for the parties to present the evidence regarding what the incomes actually were. Now, notwithstanding the parties having stipulated to those incomes in the proposed child support guidelines offered by the appellee, the figures that the trial judge pronounced, they're the product of mathematical error. The court was clear about the formula it used in reaching the pronounced figures it made. Specifically for the year 2018 and 2019, the trial judge indicated that he used the year-to-date net pay from the appellant's pay stub and divided it by 12 to reach his calculation. And in taking the figure from the pay stub 2018, dividing it by 12, you do in fact get the figure pronounced by the judge, $6,763. When you go to the next year, to 2019, and use the exact same formula, you get a different figure than what was pronounced by the judge. Albeit it was only several $100s different, it is in fact a mathematical error and difference. If that were the only issue here, we wouldn't be here. But when we move on to the next year, the most important error mathematically was the year 2020 for the ongoing calculation of child support. There, the trial judge indicated a formula for projecting the appellant's current income, and he used a figure of 26 days in order to project the income between January 1st, 2020 and February 1st, 2020. That is a clear mathematical error. It's indisputable. There are not 26 days between January 1st, 2020 and February 1st, 2020. There are in fact 31 days. It's a mathematical certainty. And in further support of that, if you were to take the 2020 pay stubs that are all part of the record here and add the net pay on each of those pay stubs for the 26-day period that the judge referenced, you'll come up with a figure of $4,048.05 versus the $5,858.57 the trial judge pronounced. That's a difference of nearly $2,000 on a monthly basis. And it resulted in a dramatic incorrect calculation of the child support in this case.
But wasn't that the correct number of days if you're looking at the pay stub?
No, it is not. The pay stub indicates net pay, the total amount that he was paid from.
Is that a separate issue than the 26 days, or?
No, it is not. There's two issues with the net pay, and I'll get to the second one in a minute. The first issue with the net pay is what he was paid from January 1st through February 1st of 2020. That is a 31-day period of time. However, the judge said 26 days. Now, if you look at those pay stubs and the dates for the pay periods, there's 26 days worth of pay stubs produced. And if you total the net pay of each of those pay stubs for the 26 days, it results in the 4,048 figure, not the 5,858 figure. That's because there was another 5 days that was year to date that is not included in those pay stubs. Thus the reason for the difference between the 26 and the 31. That additional week that the judge included his income but didn't factor the 5 days in, the appellant had made another roughly $1,600. And that's the reason for the mathematical error. It's understandable how it happened, but numbers don't lie. The year-to-date income was $5,558, but the income for the 26 days was only $4,048. It's clear on the pay stubs. It's simple mathematics. It was a mistake. It shouldn't have happened. Now, the other issue relating to the net pay is that the final judgment and the sums pronounced at the conclusion of trial include per diem payments that the appellant receives as income. Now, it's unclear if the trial judge intended to include those payments as income because he never made any findings in this case as to the party's gross incomes, as is required by Florida Statute 6130. There was no pronouncement at trial. The transcript, there is no talk of gross incomes whatsoever. The child support guidelines worksheets that are part of the record make no mention of gross incomes. They start with a net figure. And because of that, it's not clear whether or not the trial judge intended to include the per diems as part of the appellant's income. It is clear that they were in fact included. The source of the confusion, I believe, comes from the language used on the pay stubs. The pay stubs have a line on them that says net payments, which is much different than net income. The net payment includes the appellant's per diem payments throughout the year, whereas a net income would not. The reason being is because the per diem payments are for the purpose of business expenses. And the only evidence that was offered at trial was that of, regarding this issue, was that of the appellant, who testified that the per diem was for the purpose of compensating him for business expenses that he incurred as a result of his employment. Now, there was absolutely no evidence at all that the per diem reduced his living expenses, which was what would be required under 6130A13 in order to include those per diem payments as part of his income. There was no evidence regarding that whatsoever.
And Mr. Studeman, the burden of proof on that issue is on who?
The burden of proof to establish the income of the appellant would be on the appellee. They did not offer any evidence whatsoever.
But to show that the per diem payments reduced living expenses, that's specific. So that would be the burden on the.
It's my understanding the burden to show that those payments reduce living expenses, that burden would have been on the appellee. That being said, my clients offered testimony that those payments did not reduce his living expenses, that they in fact were reimbursements for business expenses, and that was the only evidence offered on the matter. We cited the Loro v. Loro case from the 4th DCA in support of our argument there, and in that court, similarly, the appellee wife offered absolutely no testimony that the per diem payments were for business expenses, and the court found that it wasn't includable as income for the calculation of child support. For those reasons, we believe that the appellant's incomes that were used in calculating child support in this case are dramatically wrong. One, the party stipulated to one amount. There was no trial held to have that amount disputed, and then different amounts were pronounced at the end. The amounts that were pronounced at the end are the product of mathematical error for the year 2019 and 2020 per the trial judge's own formulas. And in addition, then these per diem payments come in. There was no finding by the trial judge that these per diem payments reduced the living expenses of the appellant and that they should be included. It appears they were included just as a mistake because of the language on the pay stub that said net pay versus net income. The other issue in the calculation of child support here was the one income matter that the trial judge indicated would be heard at trial. It was the income of the appellee for the year 2020. Now, on that issue, there was some discussion whether or not the appellant was attempting to impute income to the appellee. And this is definitely a source of confusion, and the fault certainly falls on the appellee in this matter. In this case, the appellee filed her financial affidavit on February 15th of 2019. And thereon, she indicated that she had a $400 per month income from a rodent and fields. This is a second job that she had. Now, part of the exhibits at trial was her 2019 1099 from rodent and fields, showing that she had substantial income during the year 2019. It's exhibit 13 in the record. The appellee didn't amend her financial affidavit as required by Florida Family Law Rule of Procedure 12.285. She failed to amend having left her job at Roden and Fields for at least 7.5 months because she didn't file an amended financial affidavit in this case until she filed her pretrial memorandum, which was in mid-July of 2020, which was at least 7.5 months after she allegedly left this position. Now, throughout the pendency of the entire case, the parties had disputed whether or not this Roden and Fields income was to be used in the calculation of child support. And so when the Roden and Fields income didn't appear on this amended financial affidavit in the pretrial memorandum, it didn't raise any flags whatsoever that the appellee wasn't working for them anymore. It wasn't until her testimony at trial that the appellant even discovered that she had in fact quit her job working with Roden and Fields. She even testified that the reason behind her quitting was that she didn't have time because she was working 6 days per month at her other job. That's per month.
Wouldn't that be something that would factor into whether income should be imputed? Best efforts, isn't that the standard?
I think the issue is not whether it should be imputed, but whether or not the appellant pled to impute income, as is brought up by the trial judge.
So if it's not a failure to impute, could walk us through what the error was in your estimation?
I'm sorry, I didn't understand your question.
If it was not a failure to impute, can you walk us through what your argument is about what the nature of the error was?
Well, it was a failure to impute. The issue, I think, is that the appellant didn't plead to impute income. And the reason is the appellant didn't know that the appellee was no longer working in that position until she testified at trial. And that's because she failed to timely amend her financial affidavit or otherwise notice the appellant that she quit her job. So essentially, she escaped that income from child support calculations because she quit her job during the parties' divorce proceedings and didn't amend her financial affidavit to notify the appellant. The appellant had no idea she quit that job. If he had, we would have amended our pleadings to impute the income. But we had no
Mr.
knowledge.
Studeman, you're at 4.5 minutes. You can use your time the way you see fit, sir.
Understood, Your Honor. Thank you. And so for that reason, her failure to timely amend and notice the appellant that she'd actually quit that job, we believe that her income should have been imputed, even though we didn't plead to impute her income. Our argument at trial was that this was current income that should be included in the calculations. We had no idea that she quit her job until she actually testified to the same during the trial. Lastly, there's an issue of costs and attorney's fees here. And the appellant's motion for relief from the final judgment, he did motion the court for costs and attorney's fees for post-judgment litigation, and that motion was denied absent a hearing. The appellant clearly pled or alleged that he had the need for contribution from the wife and that she had the ability to pay.
Wasn't there a stipulation regarding attorney's fees?
Not regarding post-judgment litigation, no.
Mr. Studeman, just real quick. You had said that okay, no, you know what? I'm going to ask you when you come back up for rebuttal because thought just lost me. So you had just made an argument that I was going to ask you a question. I'll come back to it. Thank you.
Understood.
All right, you wish to reserve your time, sir?
Yes, Your Honor.
All right, you have 2.5 minutes. Morning, Ms. Griffin. You may proceed.
Good morning. May it please the court. My name is Eileen Griffin, and I am representing the appellee, Ms. Laura Elise McDaniel. And we are asking for the court to affirm the final judgment, which was entered by Judge Tibbles on September 11th of 2020. The case was tried before Judge Tibbles on August 26th of 2020. There was a marital settlement agreement which was reached at a mediation session, which resolved all of the equitable distribution issues and had provided that each party was to pay their own attorney's fees and had a long distance parenting plan for the parties. The court reserved jurisdiction, or the parties reserved jurisdiction to have the issue of retroactive child support, which was included the ability to modify the temporary child support, which was paid after our first mediation, and for ongoing child support. It is disingenuous for Mr. Studeman to argue to this court that there was an agreement about the income at the beginning of the case. His exhibit number 8 was his proposed child support guidelines worksheet, which had Mr. McDaniel's income at $3,813 a month. And throughout the proposed exhibits that we had, number 1, number 3, and number 5, we had an amount for number 1 was $55.22 a month. For number 3, which was number 1 was for 2018. For number 3, which was 2019, we had $49.23. And for number 20, it was $48.78.
Suffice it to say that there was a clear difference in the assertions regarding income. And would you say that what was stipulated to was merely the entry of certain exhibits, not
correct, Your Honor?
The ultimate conclusion
it would be impossible when you read through the whole transcript, and Mr. Studeman's position throughout was that the child support for his client should be $398 a month, where our exhibit 1 was $2,462 a month, our exhibit 3 was $2,037 a month, and our exhibit 5 for ongoing was $1,858 per month. And that was, and throughout his position was that the father should pay $398 a month for 4 children. Mr. McDaniel worked for a company called On Power, and he was a lineman. And Judge Smith, you had asked Mr. Studeman if the earnings statements were admitted in evidence in the initial exhibits that were admitted, and they were in fact admitted as the exhibit number 14, which shows the year-to-date income for 2018, 2019, and for the period in 2020 from January 5th through February 1st. And the dates are up in the top corner of
And Ms. Griffin, and I'm familiar with those. And so if you look at those earnings statements, I think one shows for 2018 shows them at 90,000, 81,000 net. But then when you look at the W-2s, there's a discrepancy. The W-2s are $72,000 and some change. And so I guess the question that I have is on these per diem, as you all have called them, was there any evidence that the per diem amounts that he received through his work reduced his personal expenses such that that the court should have included them in calculating that income?
Your Honor, throughout the case, the facts were undisputed that Mr. McDaniel was living down in the Port Charlotte area with his girlfriend in a home and was telling his wife that he was living in a hotel. And he was living with his girlfriend in the Port Charlotte area.
But I guess some of this has to do with amounts that he received when he was away on, disasters, correct? I mean, he had hotel stays, he had per diem amounts that he would receive for food and whatnot. So how did those amounts reduce his personal expenses?
Well, Your Honor, it
And
was
the only, yeah, and the evidence that was in the transcript, discussed that they did not. So I'd like to hear from you. What was there competent substantial evidence in the record that showed that his personal living expenses were reduced as a result?
Your Honor, in 2018, Mr. McDaniel his home was in Plant City, and he was living in Port Charlotte with the girlfriend. And so he was getting per diem because he was in Port Charlotte. And so that was paying where he was living, and he wasn't living in a hotel. He rented a house with this woman that he was having the relationship with. And I'd like to point out to the court that on those earnings statements, there are entries not just for per diem and meals. Meals for 2018 were only $555. Per diem was $18,209. The on-power entry of $49,488 is the only part of income that Mr. McDaniel was asking the court to consider in determining what his income was for the retroactive child support and the ongoing child support. There's an additional overtime payment in that one statement of $4,369.07. And there was a storm entry, which is called HYEQOPDT, which was an additional $17,623.84, which Mr. McDaniel was completely excluding from his income. Similarly,
And Ms. Griffin, how can we show, or what evidence was in the record that show that those amounts were excluded from his W-2s, which has the different amount, the lower amount of $72,000? Was there any record evidence? I know you're referring to the earnings statement by themselves.
But I'm also addressing Mr. Studemann's client's financial affidavit that shows his income on the latest financial affidavit, which was exhibit number 20. And that was dated on July 13th of 2020. And he has his total income at $5,143 gross, which is a little over $60,000. And these other sources of income he's had consistently every year. And Judge Tibbles made a specific finding that the income that he found for each of these specific years were consistent with what Mr. McDaniel earned in all of these other years, that as evidenced by the records that were in evidence. The short period of time in 2020, he only produced that 1 month from January 5th of 2020, where it says from the date of January 5th, 2020 through February 1st of 2020, Mr. Studeman said that it excluded a week. Well, it didn't exclude a week because January 5th, the payment before that would have been in 2019 and included in 2019 income. So that would have been doubly dipped. And so we go to trial on August 26th of 2020. And the only income statements that Mr. McDaniel produced is this one month or 26 days of income. And the reason that he didn't do an updated proof of what he earned was because he was sent to New Jersey for storm damage, and he was making in excess of $100 an hour. And his testimony is clear in the transcript that he did that. And his income would have been probably much higher than that. And we didn't have that evidence. So Judge Tibbles, given the limited amount of evidence that he had, used exactly what he had and averaged that out over the 26 days, which resulted in the number that Judge Tibbles came up with. And it was so consistent with everything that he had earned previously. And the appeal itself is surprising. Our child support guidelines in that exhibit number 1 that Mr. Studeman said was agreed upon at the onset of the trial, we requested $2,462, and the final judgment ordered $1,998. So they prevailed by $500 almost in 1 month in that retroactive for 2018. Again, in 2019, my exhibit number 3 was $2,037, and the final judgment ordered $2,025. And it certainly, they gained from what was for the husband to pay a lower amount than what I even had in those numbers. So he's wanting it both ways. He wants to keep the 10% reduction that Judge Tibbles gave them. And specifically in the final judgment, the court ordered that the husband is entitled to a 10% downward deviation. And he makes findings of why he was entitled to the downward deviation, and which included the husband's superior union health insurance, the husband's seasonal income, the husband's inconsistent state and local union dues, and the assistance that the wife received from her family. So for each of these amounts of child support that Judge Tibbles found based on substantial competent evidence, he also gave him a 10% deviation in the second hearing. We had the final hearing on August 26th. Judge Tibbles specifically said on page 70 of the record, every guideline will have to be recalculated because nobody put the correct net incomes. On page 171, Judge Tibbles said, you shouldn't have to make any tax calculations. I've determined net income for both parties. And Judge Tibbles then did the net income recited on the record in his ruling on page 166 that the court finds that the wife's net monthly income for 2018 is $24.98. Husband's net income is $67.63 for child support purposes. That his net pay for the year of 2018 is $81,186. The husband is not credited with any child support payments for 2018 in November or December. The husband shall have arrears if it is calculated as having arrears for those 2 months. There is no credit for the wife for child care in 2018 and no deviation from the child support guidelines for 18. For 2019, the court finds that the wife's net monthly income is $41.55. The court finds the husband's net monthly income is $63.12. That is also calculated with the same methodology using the second page of Exhibit 14, which is the last pay stub for Mr. McDaniel in the year of 2019, reflecting a net pay of $75,434.60. For the year of 2019, the wife will be credited with an average of $533 in child care costs. This reflects $400 per month for January, February, March, April, and $600 per month for May through December. If there is an arrearage, Mr. McDaniel will be credited with $6,880 in child support payments made for 2019. For 2020, the court finds the wife's net monthly income is $49.47 and the husband's net monthly income is $68.54. The court used the same methodology to calculate both net incomes based on the record evidence. The court calculated the wife's by her pay stubs, which are included in Exhibit 15. The court calculated the pay to be over the course of 80 days with a net pay of $13,010.06. The husband's net monthly income for 2020 is $68.54 per month. The court utilized Exhibit 14 in the pay stubs for the year 2020 in that calculation. Your Honors, I will acknowledge that there is an error in the math calculation of Judge Tibbles, and I believe it is only for $25. And the court found that his income was, I believe, $63.12 for 2019. And the math equation that I calculated was $62.86, which was a $25.78 within, which practically speaking would not make any difference in the child support guidelines if the husband's income was $25.78 less for calculating child support guidelines for 4 children. That would be harmless error. It would be an injustice to reverse this case over a $25.78 mistake by the trial court in doing that math equation. With regard to the Roden and Fields income, Ms. McDaniel testified that it was a multi-level marketing skincare product line that she sold when she was living in Plant City, Florida. She stopped doing that when she moved to Alabama, and she was not able to continue with that product line when she moved to Alabama, and she stopped selling the Roden and Fields line. I would ask the court to accept Judge Tibble's very specific findings of fact that he found based on the record evidence, including the fact that Mr. McDaniel did not provide updated information from his employment, which would have had a significantly higher amount. We're not appealing and filed a counter claim on any of this or a cross appeal, and we would ask the court to affirm Judge Tibble's final judgment in total. Thank you.
Thank you. All right, sir, you have 2.5 minutes.
Your Honors, the transcript speaks to itself regarding the stipulation regarding income. It's pretty clear that the trial judge was referencing specific exhibits with specific net income amounts, and the appellee agreed that they were correct. There was no trial to dispute those figures. That being said, Florida statute 6130, I believe, indicates that in order to derive it, the party's net incomes for calculating child support, you must subtract it from the gross income. The court never determined either party's gross income in this case. It's absolutely impossible for him to have arrived at the correct net income. He didn't follow the statute. He made absolutely no findings whatsoever regarding the per diem, it being income or not. But the only evidence that was offered was that it reduced the appellant's business expenses. There was absolutely no evidence that it reduced his living expenses. It could not have been included as income because it didn't satisfy the statutory requirement that it reduced his living expenses. There's some talk about storm pay when my client, Mr. McDaniel, was in New Jersey. However, if you review the transcript, you'll see the testimony was that was a one-time thing that had never happened before in the past. It was a short period of time. I think he testified he was there for a week and that he was not expected to ever go there again. There was no findings by the trial judge that that was included in or projected into his findings as far as the party's net income. The judge gave a very specific formula, how he calculated the net income for the year 2020, it included this factor of 26 days from January 5th, 2020 to February 1st, 2020. But again, those pay stubs are of record. If you take the individual pay stubs and the net pay from each one of them and add them together, you will get a figure of 4,048, not the figure indicated on the net pay of the February 1st pay stub that indicates 5858. That's because that other $1,800 was made during the 5 days not included in the projection, which would have drastically lowered the income, even if these per diem payments were to be included. But the fact is they shouldn't
All
have
right,
been.
sir. You got 30 seconds.
Your Honor, we request remand for the court to enter a judgment consistent with the party's stipulated incomes, or in the alternative, to calculate it absent the inclusion of per diem payment because they weren't supported by the evidence. We also request a hearing on post-judgment litigation. Thank you.
Thank you very much. Thank you both. Well argued. We're going to take a 10-minute break.